Howdy, and welcome to the show. Cooper's Code examines a legal issue and hits that issue's key practice pointers and strategic highlights so that we can all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Hendrick White, our pre-litigation and intake manager, we'll be discussing a big change in the law as of January 2023 for pre-lawsuit demands with the introduction of California Code of Civil Procedure, Section 999. Before we get into today's topic, a few words about Cooper's LLP. We at Cooper's are committed to thought leadership, developing the best talent, and honing the skills through learning, practice, trial, and the relentless pursuit of justice for consumers. With lawyers licensed in California, Oregon, and Washington, we're available for free strategic consultation on cases, and we accept referrals and trial co-counsel opportunities. For more information, visit our website at coopers.law. Hendrick, welcome to the show.
Thanks for having me.
Setting us off on the path, let's talk a little bit about the history behind why the Code of Civil Procedure Section 999 came about. And to do that, I want to set the stage. There are insurance companies out there. There are lawyers who represent claimants out there. Some of the lawyers who represent claimants were doing what insurance companies refer to as gotcha demands. They were issuing a demand letter saying, pay us the policy. They would send it out on a Friday afternoon. I'm giving an extreme example. Friday afternoon. And the demand would be, unless you have a check in my office on Monday, the time period to accept this has lapsed. And then they'd turn around and they'd say that the insurance company had behaved in bad faith. And they'd try and pursue a open policy through bad faith litigation for the insurance company's failure to accept that very short duration demand. That's the background for how this law came about. It was negotiated between the consumer attorneys and from the insurance companies to try and come up with something where the insurance companies didn't feel like they were receiving these gotcha demands that then turned into bad faith. So I think that's a nice backdrop to ask you, from a pre-litigation perspective, how has your department approached these types of claims even before 999 came about?
Yeah, so when we submit a demand, we're sending all the information they need to make a decision on our demand. We want to make a demand within the policy. If we know the policy is $100,000, we don't want to demand like $500,000. So you want to be within it. Normally policy limit demand, and we want to give them enough time to review the information, most of the time 30 days. If they feel like they need some additional documentation, anything like that, we're always really flexible with them. The interest is the client, and being a hard nose on that doesn't help in the end if you do get into the spot where you can actually pursue a bad faith claim. You want to give them enough opportunity to make a decision on the case.
One of the things I know I hear from insurance bad faith counsel when we are consulting them, hey, have we set it all up in a way where you can actually prevail in a second insurance bad faith case? One of the comments that I frequently hear is give them enough rope to hang themselves. And when you think you've given them enough rope, consider giving them even a little bit more. As far as responding to information from the insurance company, asking for more material, is that something that you have found is helpful in order to make the claim bulletproof?
The more they stall and the more they ask for more documentation, the more it looks like they're stringing you along. And I think that helps in the bad faith. And it shows that, we've been completely reasonable through this negotiation, and they have not. I think it's in the best interest for the client and for the case, yeah.
And as far as getting the types of information that is typically provided, does that include the police report?
Yeah, police report and medical records. Sometimes on some cases, you may not have the wage loss or the future wage loss really worked out in the demand stage, especially in pre-litigation. You haven't really hired an economist or anything like that. So a lot of times they're asking more information on specific parts of your claim. So wage loss comes up a lot. Always a little reluctant in the demand phase to start turning over documents that, like maybe tax filings, stuff like that. Getting them what they ask for timely. You don't want to drag your feet too when they ask for that stuff. If they respond 30 days from your demand and say, hey, can you send me pay stubs? You don't want to take 3 months to get them pay stubs if you can help it. Then you start looking at unreasonable too. And it takes away the leverage that you're building up to maybe push it into a bad faith type situation.
There are some lawyers who feel that a case should be filed from the outset instead of going through any sort of pre-litigation phase. And there are other lawyers who feel that the pre-litigation phase helps in two different directions. One, to help the insurance company properly set reserves by getting all the information like medical records so they can recognize that this is a credible, real, serious claim. And also in cases where the policy limits may be lower, to be able to efficiently resolve the case without the full cost of depositions, filings, and expeditious result for the client. For the lawyers who feel that it should be filed right out of the gates, what are your thoughts as far as that is concerned?
With my experience, I think filing right out of the gate maybe is useful in a small percentage of your cases. You gotta look at the cost benefit. You probably don't know the defendant's policy in the first 30 days. I mean, what we do right off the bat, and maybe getting into another topic right now, but what we do right off the bat is try to determine what the third party, when I mean third party, is defendant's insurance policy limits are.
And actually, that was exactly where I was going to go, and I was going to ask you for the techniques, because a lot of lawyers say, well, they won't give it to me. How do you deal with that?
We do a series of letters. I mean, it starts with the letter of rep. We have a list of things that we're asking for them, and one of those is get authority to disclose your insured's policy limits.
And on that, when you say get authority, insurance companies will say, I can't release that without my insured's authority. That is an honest statement. It's not positioning, correct?
Yeah, almost 100% of the time I hear that within the first 2 weeks of the case, yeah.
But they can get authority from their client. What tools do you use to help the insurance company convince the insured to release that information?
Once you get the letter rep out there, make sure one of your requests in that letter is disclose your policy limits, disclose whether or not course and scope of employment. You want to find all that stuff out. Likely you're going to hear, I don't have authority. So then I think the first step, the best way to do that is get on the phone with the adjuster. You're like, hey, in my letter of rep, I laid out what our injuries are. It's in everyone's interest to resolve this case as soon as possible. The best way to do that is letting us know that what your insured's policy limits are. We can maybe get this resolved quickly by me just focusing on getting some medical bills that prove that, this case is worth the policy limits, instead of us spend 6 months at least getting all the medical in, getting all the damages in, and finding out later that, this was only a $25,000 or $30,000 policy limit. And we had that with our first ER bill and a couple other things.
Are you successful the vast majority of the time with getting those policy limits disclosed without having to file a suit?
I'd probably say more than half with some phone calls. Not much more than half, a little less than half the time. You're going to hear, I don't have authority. If you don't follow up with them, who knows if they even contact their insured to ask? I don't know. So when that starts happening, when you feel like you're starting to get dragged along, maybe 2 or 3 weeks after the letter of rep, we put together a letter that has kind of like a declaration or an affidavit in there that basically is addressed to the insured care of the adjuster, meaning like, hey, we're addressing this to your insured. You need to send it to them. And in that, we're basically having the insured either fill out the policy limits, and if there's any excess insurance, umbrella insurance, you could checkbox that and fill it out. Or the other checkbox is, I'm not going to disclose and I'm going to sign this. And so that way we know, okay, they're going to play hardball here. Sometimes the adjuster will give verbal clues on what this policy is without telling you what it is. For instance, you may hear it's not a minimal, or they may say, there's enough. So then you can kind of start judging like, okay, the bills that we have are looking at, we're in the $50K range. Enough means we're probably in the $250 policy range or more. Sometimes the adjusters can't get a hold of their insured at all anyway. So try your best in the first 30 days to get that bottom line there.
As far as CCP 999, what I understand it covers are any pre-lawsuit demands. So something that is a demand that is made before a lawsuit has been filed, that it's made by lawyers, meaning it doesn't cover a demand that is made by an individual saying, hey, will you please settle my case? That it covers any demand submitted after January 1st, 2023, and it is for personal injury cases, not medical malpractice, not employment, not anything else. And within that, there are now some new burdens under 999. Now, as you already talked about, a lot of these burdens are things that bad faith counsel would like all of us to do anyway. These include that there is a 30-day minimum to accept it if this is sent by email or fax, and 33 if it's done by mail, that somewhere on the demand, it needs to be labeled either as a time-sensitive demand or the demand is made under CCP 999. Have an understanding as to why that's the case?
On the plaintiff side, you want them to know, like, hey, this is under CCP 999. If you mess up, there could be bad faith here. You want them to understand that. But also, a lot of your demands that you send, they're scanning through their system and it's going to flag certain words probably. And you want CCP 999 pinged on your demand so they treat it appropriately.
I'm guessing, given that you're a belt and suspenders kind of person, that the demand packages that we send out reference the phrase time-sensitive demand and also include the phrase CCP 999.
Yeah, what we do is we send a cover letter with our demand. The way we do our demands, it doesn't look exactly like a letter. Like we have a cover page, shows our client, we have table contents, all that stuff. So we send what we call a demand package, but we attach a cover letter that lays out all the 999 language. We also talk about how the insurance company doesn't actually have the insurance best interest. And we're also addressing our letter to the insured, the adjuster, the insurance company's decision makers, basically making sure that anyone that has authority has eyes on this.
And I want to give credit where credit is due. Some of the ways that we approach our pre-litigation demands, also our in-litigation demands, come from Nick Rowley and Courtney Rowley's Running with the Bulls. Side note, if you have not read that, bought it, it is essential in order to maximize getting a good settlement for your case instead of dragging your case through trial.
Yeah, I agree completely. That was a great read. And since reading that maybe 4 or 5 years ago, we immediately started implementing a lot of what Nick talks about in that book. And I've seen just huge changes with third-party demands.
So going back to the requirements under CCP 999, and as an aside, these are all included specifically in the new statute. So it needs to be sent to an address for the insurance company that is listed at the Department of Insurance that has been specifically set up for these demands. As a side note, expect this to create chaos because requires the Department of Insurance, an outside agency, to set up this new webpage and for insurance companies to have a system for updating these addresses.
Also, I think that that's an option if you don't have the adjuster's information, right?
Absolutely. It can go there if there's no adjuster assigned or no claim number has been assigned already. But if there's an adjuster, you can send it to the adjuster if known. You can send it to both. And do you have a preferred practice in terms of how you approach things?
Generally, we're either trying to get it straight to the adjuster or get it to where their response to our letter of rep, where they say to send any documents. If there's none of that, then we would go to the Department of Insurance for the address listed there.
So in terms of what needs to be included in the 999 demand, the terms must be specific and they must include details. There needs to be a clear and unequivocal offer to settle all claims within policy limits, including the satisfaction of liens.
Yeah, so a point on that, going back to figuring out policy limits, the question gets raised, I don't know what the policy limits is, so how do I know if I'm within the policy limits? And what we've been doing is figuring out, deciding what we're going to demand and then saying, say we're going to demand $500,000. This is a clear, unequivocal, time-sensitive, time-limited demand to settle all claims for $500,000 or the policy limits if the policy limits are less than $500,000.
So that's the way around it if they fail to disclose.
So far.
Okay. The demand also needs to include an offer for a complete release from the claimant for the liability insureds from all present and future liability for the occurrence.
Correct. Yeah. And we weren't using that language previously. And now I just basically took it right out of the CCP 999 to the exact same language and added it right in there. Another point on all these specific terms, we're putting that in our cover letter and in our last section of our demand package where we make the demand. So it's in multiple places in case the cover letter gets separated or considered a different document. I don't know. We have it in multiple places throughout the demand.
Belt and suspenders again. None of us want to be the folks being talked about at What's New in Tort and Trial as to why their demands did not meet the burden of CCP 999 and why the case is not in bad faith.
Yeah, over precaution.
999 also requires the date and location for the loss, the claim number if it is known, a description of all known injuries sustained by the claimant, reasonable proof, which may include, if applicable, medical records or bills sufficient to support the claim. And maybe you can tell us a little bit here about how you organize that and what you do there.
We start off with a narrative, and the way we approach the narrative is, if we were going to do our opening argument in trial, what would it sound like right now? So we're including pictures, photos. We're talking about how the incident occurred and kind of foreshadowing the damages that we're going to discuss more in detail. And then any kind of like persuasive details of the facts that we want to include in the narrative. From there, we discuss the parties and any information we have on the defendant that's helpful for our case. And then move into like the injuries, the damages. We chart out the economic damages, and then we go into a big discussion on general damages. We also include an exposure table where we're basically saying, if this goes to trial, this is your exposure, the insured's exposure, even if it's way more than what the policy limits are. And then we are making a demand with the logic like, hey, this is your exposure, but we're going to make a demand for this to see if it's possible to settle without going into litigation.
One of the things that I've learned from the bad faith lawyers as kind of a rule of thumb is, if you want the bad faith jury, if it ends up in bad faith, to be able to consider it later, then you should probably include it in the package.
We discuss the bad faith stuff in the cover letter that we send. We go on and we list a little case law about the insurance's duty to their insured. And then we have a little discussion about how the insurance doesn't have your back, speaking to the defendant. Their bottom line isn't keeping you out of litigation or taking you into trial. Their bottom line is what's best for the company. And then we also recommend a couple of bad faith. This may arise, and here's a couple of bad faith attorneys that you can call if you need to.
And again, giving credit where credit is due, this is something that the Rowleys suggested in Running with the Bulls, and we've found very, very helpful. With 999, nothing precludes the adding of additional acceptance terms. So you can include a declaration for the insured to sign that there is no additional insurance, to make sure that there's no excess policy out there. You can include a declaration about assets. And ultimately, the failure to comply will mean that the offer will be deemed unreasonable in any later bad faith efforts.
Right. And what we've been doing is, if we end up getting the policy limits tendered, that's when we're looking into sending a deck of no additional insurance or a deck of assets. One thing from Nick and Courtney's book, they made it clear that in your demand, you want to be simple and not don't have like a compound demand. Like, you want to demand the policy limits. You don't want to pay the policy limits to your subscription to Encyclopedia, something like that, where that makes it complicated. So I still kind of feel like throwing in, and you have to sign a deck of assets, and you have to do this and this and this. I kind of be like, well, let's wait to see if we get the policy, then we can go into that instead of sending it all at once. But I don't know whether that's the best way to do it yet. But that's what we've been doing since CCP 999.
And to come back at that, if you don't do all of the steps, in essence, the checklist that is laid out by the statute, the offer will be deemed unreasonable if you try and move it into bad faith.
Yeah.
Once all those hoops have been jumped through, it's then the insurance company's ball.
It's in their court, yes.
When that happens, what can they do?
My understanding is they have the opportunity to request clarification, ask for additional documentation for proving parts of the claim, which we talked about earlier. You want to be reasonable and give them what they want in a reasonable time. They have 30 days or 33 days if you mail it to accept in writing is another thing they have to do, which in the past has always been a phone call, like, hey, this is our offer. And then in that letter, they have to explain their reasoning. We used to have to pull teeth to get the reasoning out. So that's kind of nice.
If the carrier rejects the time-limited demand, it has to do it in writing. It has to do it within the time to accept the demand. And it has to articulate the basis for its rejection, which I will say it'll be interesting to see how these form letters start coming together, because I am certain they're not going to be giving their adjusters the authority to put specific words in how they're making the rejection.
Yeah, what I've noticed so far, we've gotten a few demands out since January 1st. Their explanation has been, this is what we're valuing your economics at, and this is what we're valuing your general damages at. And then if you want more, you got to pull teeth. And we want more because we need to decide if their reasoning is reasonable And then we also need to go to the client and be like, hey, this is what they're thinking. This is what we're thinking. And so what do you want us to do? Or this is what we suggest doing. What do you want to do?
As CCP is a new statute, we expect insurance companies to make mistakes. Use the statute as a checklist so that all the mistakes are on their side and not on the side of those of us who are fighting for our clients. Anything else, Hendrick, that you think we should chat about as it relates to this new statute and pre-litigation demands?
The only thing to add would be, as soon as you get a case, this should be on your mind on how I want to approach my demand, the strategy of the case in pre-litigation, and how to incorporate CCP 999 into that strategy.
Now, because a rising tide floats all boats, I've mentioned running with the bulls a couple times here, and the Rowleys gave us all good guidance as far as that's concerned. Have you come up with a template so far to use for CCP 999 demands?
We adjusted our cover letter for the demands that incorporates it all, and then also adjusted our demand template for the demand section to incorporate the language and everything else. Yeah.
And I trust that anyone who emailed podcast@coopers.law, you'd be willing to share that template with them.
Yeah, happy to share our template.
Well, thank you, Hendrick.
Thank you.
I want to thank you for listening today. Please email us at podcast@coopers.law with any questions, comments, feedback, and suggestions as this new statute unfurls itself. If you like what you heard, share us with a colleague and leave a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.